If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview Historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestvew's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestvew's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
All right, good morning, everyone. This is our arraignment date, or sometimes referred to as plea date. What I'm going to do is call each case alphabetically, so that should help you prepare as to when your case will be called. What I'm going to do is call up each person, make sure they understand what they're charged with. So I'll announce your name, your case number, as well as what your charges are. Make sure you understand that. Then I'm going to ask if you can afford an attorney to represent you. If you cannot, we'll have you fill out a form and turn it in before you leave today, but I can appoint the Public Defender's Office to you. We have Mr. Williams and Mr. Russell here from the Public Defender's Office, and Ms. Rivers, sorry, she walked away. And then we have two state attorneys, Ms. Leone and
Ms. Turner.
Ms. Turner. Sorry, I was just looking at something on my docket. I'm very distractible today for some reason. Who are here from the state, and I know this is called plea date, but it's often because of these being felony charges, not a whole lot is resolved today, but we may get to that point if possible. But I want people to have a chance to speak with an attorney before they make any decisions. Just the other thing is, make sure you understand that everything in this room is recorded, both audio and video. And the reason I want to make sure you understand that is we don't want you talking about the facts of your case today. If you have an attorney that gets appointed, you can certainly talk to them. But anything that you say that could be detrimental to your case is recorded, and again can be written down by Ms. Turner and Ms. Leone at the State Attorney's Office, and can be used potentially against you in your case. So you have to be careful about that. Let's get started with Joanne Carnes. Ms. Carnes, you're here in 24 CF 2775, possession of a controlled substance. Do you understand that charge?
Yes, sir.
Okay, and just so everyone knows, when I said you understand the charge, it's not about whether or not you agree with it. It's about you understand what you're actually charged with.
Yes, sir.
All right. Ms. Carnes, can you afford an attorney to represent you in this case?
No, sir, I cannot.
You cannot? Okay, so I'm going to go ahead and appoint the Public Defender's Office for you. Mr. Russell's coming up from behind you to help you out. But we will need you to fill out one of those application forms and turn that into the clerk's office.
I have to get my glasses on my purse.
Judge, the state has filed an information in Ms. Carnes' case, so we're going to plead not guilty, request a jury trial, and 15 days to file a pre-arraignment motion.
Okay. Ms. Carnes, we're going to have you come back for your next court date. It's going to be a pre-trial conference date on February 24th at 1:30. Make sure you stay in contact with the Public Defender's Office. It may not be Mr. Russell who's ultimately assigned to your case, but you can contact their office, make an appointment, talk to them about your case going forward.
Thank you, sir.
All right. All right, Ms. Carnes, can we have you step up for a second? You want to do that now, or?
Well, Marnie's going to come in.
Okay, if you could hang tight, they have to do a DNA for you because it's a felony arrest. So we're just going to wait for another deputy to come and help us out with that. All right, Jeffrey Castile.
Charles Russell, Public Defender's Office. Judge, Mr. Castile is present and approaching. Case number is 24 CF 2755. State's filed an information. We're going to plead not guilty, request trial by jury, 15 days for any pre-arraignment motions, and your next pretrial conference date.
All right, February 24th at 1:30, Mr. Castile. Make sure you stay in touch with your public defender, and we'll see you back on that date.
Thank you.
Call us next week.
Okay.
All right, Jimmy Counsel. All right, are you Jimmy Counsel? All right, Mr. Counsel, you're here in 24 CF 2765, charged with possession of forged bills or notes. Do you understand the charge?
Sure.
All right. Can you afford an attorney to represent you?
No, sir.
All right, I'm going to go ahead and appoint the public defender, but again, you're going to have to fill out that application form. There should be one on the lectern in front of you.
Okay, Judge, the state has filed an information, so we're going to enter a plea of not guilty. Request trial by jury, 15 days for any pre-arraignment motions, and your next pretrial conference date.
All right, February 24th at 1:30 will be your next court date. Mr. Counsel, make sure you stay in touch with the public defender's office. Meet with them before that date so they can help you out with your case.
Call the office next week. Tell me you need to make it. Okay.
Okay, but that's not always the case. I got you. All right, next case is going to be Horace Durden, Jr.
Charles Russell, Public Defender's Office. Judge, if I could have a moment. Judge, this is here on case number 24 CF 2762. State has filed an information. We'd enter a plea of not guilty on behalf of Mr. Durden. Ask for a jury trial in 15 days to file any pre-arraignment motions. And we'd ask for the next pretrial conference date. Mr. Durden wanted me to let the court and the state know that the alleged victim, Sonia Watts, is in the courtroom.
I'm sorry, the alleged victim is what?
Present in the courtroom.
Okay. All right, February 24th. If you're still incarcerated, it'll actually be February 26th at 9 o'clock. Otherwise, February 24th at 1:30. If you're to be released at all before then. Is there a bond in the case?
Separate case.
Well, Your Honor, it may have a bond in this case. However, he has a VOP, and also another case. He was out on bond on another case. He's a violent felony offender of special concern. He's not entitled to a bond.
I got time served on my misdemeanor cases on the 7th, a couple of days ago.
All right, sir, but you heard several different things there. Listen to Mr. Russell. We'll have you come back if something changes. I've always got other court dates where we'd come back earlier to get things resolved if there's a change. Or is it Tanishi Gadd, G-A-D-D?
Charles Russell, Public Defender's Office. Ms. Gadd is present and approaching. Case numbers 24 CF 2791. State's filed an information. We'd enter a plea of not guilty. Request trial by jury. 15 days for any pre-arraignment motions and your next pretrial conference date.
All right. Good afternoon, Ms. Gadd. Do you understand all that? All right. We speak pretty quickly sometimes. We just want to make sure everyone gets it. February 24th at 1:30 will be your next court date. Make sure you stay in touch with the public defender who's been assigned, and then we'll see you back on that date. Malik Green.
Mr. Green is present and approaching, Judge. It's case number 24 CF 2839. State has already filed an information. This time we're going to enter a plea of not guilty, request trial by jury, 15 days for any pre-arraignment motions, and your next pretrial conference date.
All right, February 24th, 1:30.
Thanks, Judge.
Okay. All right, I think Lambert we already handled this morning. All right, Jared Mullis.
Good afternoon, Your Honor. Judge, this is Jared Mullis. I'm going to be entering a plea of not guilty on his behalf today. Request 15 days for pre-arraignment motions and demand trial by jury. The state has filed an information, and Mr. Mullis, I'm going to give you a copy of that, okay?
All right, February 24th at 1:30, or if you're still in custody, it'll be the 26th.
Sir.
All right, thank you, Mr. Mullis.
Thank you. Thank you, sir.
All right, Tatiana Migrant. Mygrant. Or anything from Miss Migrant? State.
Ask for a KPS.
KPS, no bond from Miss Migrant. Obviously, if she shows up before we finish up here today, we'll readdress it.
Actually, there was an email on Miss Migrant's case. I believe it was from Tiffany with pretrial. Yes. She was, Tiffany from pretrial told, I believe you were on the email, that an old warrant, she was picked up in Macon, Georgia on an old warrant. Tiffany made contact with the booking supervisor at Bibb County and confirmed she was in custody on a warrant for an incident, a previous incident held there on no bond, was what the email says. So
she's being held in Georgia on no bond.
we could keep the KPS just to ensure her presence here, or however your honor wants to proceed.
All right, KPS will stay in place. When you really look at it, she's allegedly committed a new offense in Georgia while on bond in our case, or no?
That would have been from September of 20, per the email. It would have, allegedly that happened prior to this incident.
To this, okay. Well, obviously I'll entertain anything that gets filed in the meantime. Recall the KPS if there is some change, but she's not here. All right, Marshall Nance, did we cover that already?
We did, Judge.
Okay.
I handled him this morning.
That's what I thought. Thank you, Mr. Williams. April Owens.
Your Honor, this is April Owen. She's before the court on 24 CF 2751. We're going to enter not guilty plea, request trial by jury. We're asking for the 2/24 court date.
All right, Ms. Owens, February 24th at 1:30 will be your next court date. Make sure you stay in touch with your public defender. We'll see you back on that date. Thank you. John Ponder. All right, Mr. Ponder, you're here charged with possession of 10 or more forged bills or notes in 24 CF 2777. Can you afford an attorney to represent you?
No, sir.
All right. I'm going to appoint the public defender. I think y'all may potentially have a conflict because of Mr. Counsel. Were y'all co-defendants?
Yes, sir.
Okay. They were sitting back together, and I know it's the same charge. I just don't, they have to potentially file for a conflict, so I can appoint you conflict-free counsel. So their office can't represent co-defendants typically.
There's no cards here for Ms. Flowers.
Okay.
B.
I'll have any cards for her? Got some RCC cards and juvenile division.
Here they are. That's where they went. Okay.
All right, so I'm gonna let Ms. Rivers, you believe the public defender has a conflict due to the.
I
what's
do,
been
Your Honor.
discussed?
Based on the information provided by the court, I would say that we have a conflict.
Okay.
That you appoint conflict-free counsel.
All right, I'm going to allow for the public defender's office to withdraw due to the conflict of co-defendants. I'm going to appoint the regional office of conflict counsel for you, Mr. Ponder. We've given you a card with Ms. Flowers' name on it. She'll be your lawyer. Come back on February 24th at 9 a.m. Because you got a different lawyer. It's different dates and times potentially. So February 24th at 9 a.m. Make sure you reach out to the Regional Office of Conflict Counsel and set an appointment with them to speak about your case. All right, thank you. We'll see you back then. Clifford Richardson. The same group, so I might need to find these voices. Okay. All right, Mr. Richardson. You're here in 24 CF 2764, also charged with possession of at least 10 forged bills or notes, as well as operating a motor vehicle without a driver's license. Do you understand those charges?
Yes, sir.
Okay. Can you afford an attorney to represent you?
No, sir.
All right. I'm going to appoint the conflict, well, I'm going to appoint the public defender. They're going to have a conflict, so I'm going to let them withdraw. I'll appoint the RCC. I'll let them withdraw, and then I appoint Marty Nopes. He's a private lawyer. Do we have any of his cards? All right. We're going to give you the information regarding Mr. Nopes. That's Knopes, to represent you. He's a private lawyer here in Crestview. But again, because of the conflict of co-defendants, we're going to have someone else represent you other than the public defender. I'm going to have you come back on February 24th at 9 a.m. as well for your next court date. Any questions, Mr. Richardson?
No, sir.
All right. See you back on that date. Make sure you fill out that application and turn it in before you leave today. Turn that in downstairs at the clerk's office. All right. Lawrence Rudd.
Where do I turn it into?
First floor, clerk's office.
Ms. Rivers, Mr. Rudd.
Yes, Your Honor. This is Lawrence William Rudd before the court on 24 CF 2754. We're going to enter a not guilty plea, request trial by jury. We're asking for the 2/24 court date.
All right, Mr. Rudd, February 24th at 1:30 will be your next court date. Make sure you stay in touch with your lawyer, and we'll see you back on that date.
Thank you.
All right, Julia Sledge. Ms. Rivers, Mr. Sledge.
Your Honor, Mr. Sledge is before the court on 24 CF 2745. We're going to enter a not guilty plea and request trial by jury.
Guilty or not guilty?
I said not guilty.
Yeah, they ain't got no, yeah, we need to do this.
All right, Mr. Sledge, I'm going to have you come back, and your next court date is going to be February 24th at 1:30. I'm sure someone from the public defender's office is going to come see you before then.
Your Honor, I have a question, if you don't mind, about the bond situation. I remember that after we had the pretrial detention hearing, the jail emailed me saying that we did not address, or I had not filed on one count. So I filed an amended information yesterday, adding 2 counts. However, for the record, I have to state that a defense counsel, Ms. Rivers, made me notice that amended information that I filed is incorrect as to count 1 because it should read attempted first-degree murder. I didn't realize that the document got processed in that way, so I will be filing an amended information for that count. However, I want to make sure he's got a bond on all counts.
What So what is she changing it?
She's
Okay, so originally count one was 350,000 cash and professional, and so this is as attempt. So you're gonna have to file a second amended information?
Yes, to reflect the attempt.
Okay. So it's only attempt. Ms. Rivers, if you feel you want to readdress the bond, you can certainly file a motion, but I think the pretrial detention order stays in place as the way it is.
Maybe, Your Honor, I didn't explain myself. I just want to verify that this defendant has a bond for each count of the information. Does he?
According to the pretrial detention order, I know you filed an amended information, but you're basically telling me it has to be amended back to attempted on count one.
I think we'll have to bring him back and then address that then.
My charge with murder.
I'm talking about the
What am I
bonds of the
charged?
last two
Mr.
charges.
Sledge, calm down.
Okay, that's fine.
There's been a Scrivener's error, a typo, basically, when they put the things into the program, it's going to be fixed.
It's not one. They say I was charged right here with premeditated homicide.
And if you listen, that's been explained. The wrong code got put in, so it comes up as the wrong thing. They're going to fix that. But
so
they just want to make sure that you understand that you still should.
I don't, because I just need the indictment information on that, because that's the probable cause of anything. And without that entity under the that's procedural misconduct under the United States versus Greer, using false identities, using false testimony to get an indictment, you can't do that. I have a right to face them people.
Is there a grand jury in this case?
No, Your
So there's no indictment. It's called
Well,
an
you gave-
information.
well, you gave me
Hold
a-
on, Mr. Sledge. I want to make sure you understand the correct terms. Indictment is handed. Am I frustrating you in some way?
Yes, because that's what I was charged with. It says, I have it right here. The lady, you said the lady was dead, and she was in fact shot 2 times in the leg. And you charged me, and that was.
I didn't charge you
Not
with anything, sir.
I know that. But we trying to file a civil suit against her for lying on the oath, and I need that because I was held without a bond until I seen somebody that they said that they gave me this charge. And
You
I
have a
was
bond, sir. Your public defender can bring it back if you need to readdress it.
It ain't even a witness. It's crazy.
All right, February 24th, 1:30. Maya Turner. All right, Ms. Turner, you're here in 24 CF 2774, charged with driving license suspended as a habitual traffic offender. Do you understand the charge?
Yes, sir.
Can you afford an attorney to represent you?
No, sir.
All right, I'm going to go ahead and appoint the public defender to represent you, but you'll have to fill out one of those applications. Looks like you've got one in your hand already. This is driving as a habitual.
Your Honor, we're going to enter a not guilty plea, request trial by jury. We'll ask for the February 24th court date.
All right, February 24th at 1:30.
Yes, sir.
Wendy Ulrich. Are you Wendy Ulrich?
Yes, sir.
All right, Ms. Ulrich, you're here in 24 CF 2795, charged with 2 counts of possession of a controlled substance, as well as 1 count of possession of drug paraphernalia. Do you understand those charges? Can you afford an attorney to represent you? No, you can't. All right, I'm going to go ahead and appoint the public defender. You're going to have to fill out one of those applications and turn it into the clerk's office downstairs before you leave today.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
All right, February 24th, 1:30. Your pretrial conference. All right. Mark Williams. That's fine. And Shaquila Wilson. Are you Miss Wilson?
Yes, sir.
All right, Miss Wilson, you're here charged with felony petty theft in 24 CF 2796. Can you afford a lawyer to represent you?
No, sir.
With the public defender, have you fill out that application, turn into the clerk's office on the first floor before you leave. Ms. Rivers?
Your Honor, we're going to enter a not guilty plea, request trial by jury, ask for the February 24th court date.
February 24th, 1:30. Be back at that time. Ms. Wilson, stay in touch with your public defender so you can talk about your case. All right, is there anybody that I missed? Mr. Williams, didn't you have one from this morning that you told your client to be here?
He was not able to. That's the gentleman that had the job interview. Kelvin?
He pled.
He pled. I thought there was another one from this morning that you had told him to be here in the afternoon.
That's the only one I recall.
Was that Mark Williams?
But that's with Miss Rivers.
Yeah.
Oh, was it? Okay.
Oh, yeah, that was.
Okay. That's the same Mark Williams that we've already called. Okay.
Yes.
I just want to make sure we covered everybody.
I had, maybe it was an add-on docket, but for 1:30, the Terry Cheshire bond hearing. Was that supposed to be on the 1:30?
Don't have it.
It's supposed to be at 2. Terry Cheshire, I see that the later
Okay.
docket.
That may be.
You have a case number on that?
Yes, 24 CF 2084. I believe that's with Ms. Rivers.
Yeah, well, yeah, it's Tim's, but maybe.
I can't even see the motion.
I think it was recently filed.
No, I'll just have to go into benchmark. You have the Cheshire case?
Yes, Your Honor. He's in custody.
They're trying to pull him up, but trying to find your motion. I can't see it.
Your Honor.
I've reviewed your motion, Ms. Rivers.
Thank you. Your Honor, this is Terry Cheshire. He's before the court on 24 CF 2084 on a motion to reduce his bond. He's charged with possession of controlled substance ×2, driving while license suspended. His bond was revoked when he was arraigned in 24 CF 2890. He would, if the court's so inclined, I'll take the testimony regarding the rest of it.
Cheshire, raise your right hand. There you go. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Would you please state your name for the record?
Terry Chesser.
You can put your hand down. Okay. And, sir, do you live here in Okaloosa County?
Yes, sir. Yes, ma'am.
And how long have you lived in Okaloosa County?
My life.
Your life? Okay. Do you have any family that live in this area?
Yes, ma'am.
Just a couple, like, mother, sister, things like that?
Mother, brothers.
Okay. Sir, are you employed?
I'm
Self-employed? What kind of work do you do?
I just scrap metal and stuff. My father passed away, and so there's a lot of scrap and stuff around the house out there that I got to get cleaned up. So I've just been scrapping and cleaning all that mess up from out there where we live.
Are you cleaning up for someone?
Well, it's not our property. It's my aunt left him. It was he had a lifelong estate there. When he passed away, it went over to the Matthews, and so I just need to get it all cleaned off and cleaned up and everything where they could take.
So are you trying to help any family members?
My mother, okay. My father just passed away, and my stepfather had just passed away.
Okay. Are you able to post your the bond that was set that you previously posted that was revoked? Are you able to post that again?
I would be able.
Then why are we here for a hearing?
They revoked it.
All right, so again, we want to be able to set a new bond amount. What amount
Right.
could you pay?
I could pay what they got me for my new one. I mean, whatever this new charge is, they got me, I think, 5,000. I could probably.
It's like in 24 CF 2890, he's got a $5,000 cash or professional on the fleeing to elude, is an ROR on the driver and license suspended.
So you're saying that you believe you
I
can make a
get-
$5,000 cash or professional on
I
this
think
one?
I probably could.
Okay. Are you asking the court to impose a $5,000 cash or professional bond?
Yes,
Will you make your court dates?
I will.
Nothing further.
Judge, the state objects to reinstatement of bond in this matter. Mr. Cheshire has, as he said, he's been a lifelong resident, but he also has a lengthy local criminal history. I believe he has 9 felony driving on suspended license convictions, as well as I think 4 misdemeanors and 4 prior DUIs. This case includes a felony driving on suspended license from September of 2024. He posted, as well as the cocaine and the methamphetamines for those 3 counts. He posted those bonds, was out on bond, and was arrested in December. Just 3 months later, he was arrested for fleeing and eluding with lights and sirens active for an incident that occurred in late November of 2024. So this is all relatively recent behavior, and these are all related to driving. The state's position is that Mr. Cheshire will not stop violating the law, and that he is, not only has he committed a new crime or been arrested for a new crime while out on bond, but that he poses danger to the community if released. So we object to the reinstatement of this bond.
Other argument, Ms. Rivers?
Yes, Your Honor, if I may. Your Honor, the purpose of bond, is my understanding, is supposed to be able to secure his appearance in court. And then the court is able to look at a number of factors when making that decision. I would ask, based on the information that Mr. Cheshire has provided, there's nothing to indicate that he would not make his appearance in court. And so we're asking the court to reinstate, give him a bond, whether it's the $5,000 cash or professional or something less.
His previous bonds were $5,000 cash or professional and drive-on license suspended, and then $3,500 each for the 2 controlled substance. But the other issue is, in addition to making sure someone shows up for court, whether or not they're a flight risk, bond is also determined dangerousness to the community. What I've got here is Mr. Cheshire, while out on bond for, let's see, $12,000 cash or professional bond on drug and driving charges, the court has found previously probable cause that he's been in a new offense, which is not only a felony, but flight from law enforcement.
Well, and Your Honor, if you will notice in reading that information, that the probable cause statement provided by the police, they pursued a vehicle. He has indicated that it was not him, that it was somebody else. He plans on, we've only met once, but he plans on trying to submit an alibi to state that he was not even in the county. So, he's innocent until proven guilty, and we would ask the court to consider providing him with a new bond.
I'm reading the probable cause affidavit of the new charge, where not only it's pretty clear that the description is given of Mr. Cheshire by law enforcement, and that they identified him at the time, based not only on his driver's license photo, but also on their own private interactions, their previous interactions with Mr. Cheshire. That report also shows that he has at least 12 violations, 12 prior suspensions, and convictions of driving while license suspended. And now he's alleged to be fleeing from the police while out on bond. So motion's denied.
So he's not going to set a bond, okay? I'll be back out to see you, or Mr. Gibbs.
All right, any other add-ons? Mr. Scott, are you ready for our 230 cases? Who do you want to handle first?
Your Honor, if I may.
Sure, Ms. Rivers.
Mr. Willis from this morning, Robert Willis, I had indicated he was on my docket, and you had indicated that it had been removed from your docket, 21 CF 3281. This was the case where the man pled out the other week to probation, and one of the conditions of probation, one of the terms was he was not have contact with Ms. Coward unless she submitted a notarized statement in writing to probation. And then probation this morning had indicated that they would want approval from you. I do have the notarized statement here.
Has probation seen it yet?
No, sir, Your Honor. His officer told Mr. Willis that we needed to get in contact with, not him, get in contact with the victim. This only happened
Monday,
right. We haven't had time. Here's that there is a notarized statement here now.
And he had indicated to me, Your Honor, that Officer Mathis had told him that this would be the quickest way, is for him just to return to court with the document.
Yeah, I see the document.
Yes, Your Honor.
My only question, Your Honor, would be, if I may,
Just for the record, we haven't said it. This is 24 CF 2162.
I asked that the victim makes the request, so the victim should have gone to probation with that paper, not the defendant. So I have some issues with that. She went. I don't.
Our office.
Filled out that affidavit with you guys? Ms. Rivers?
Okay. You can come take it back, Ms. Rivers. Just maybe you can see who notarized it, and that will tell you.
Right.
Yes, it was done.
Okay. I knew that we haven't talked to the victim. Or I know that this was not from our office. But that's fine. I mean, it's a notarized statement for what it's worth. The victim has not approached us directly. However, it looks like she has contacted the state attorney's office or the public defender's office and has
She didn't
done a
contact
statement.
me. She did not contact our office, Your Honor.
I meant the public
Was she
defender's
here
office.
Right, no, I know.
No. Not that I'm aware of.
Then just people
I
on Monday and then.
I did call.
Because if she were here on Monday, that would have explained why she knew what to do, because she would have heard the sentence that was announced. But
Right, I did call.
I think everyone's just a little bit apprehensive because it happened so quickly without anyone actually talking to her. But you're saying, Miss Rivers, that I won't announce the name, but the name of the notary is someone who works in your office.
Yes.
Any other concerns, Miss Leone?
From me, no, Your Honor, just what I said.
You agreed to it, though, so you got to do it.
I guess, here's the thing. The sentence that's announced says if she sends paperwork that comes in that says she's okay with it, then it happens automatically, right, without coming back to the court.
That was why I was having trouble understanding why we were having to go through all this.
So,
Was supposed to go to probation, Your Honor, and that would comply with the order, and it would be automatic.
well, but the way it was read each time, because we had a couple of cases that had this issue, it was no contact with the victim unless they requested in writing for there to be contact.
With probation.
With probation.
Yeah.
So, I guess what the concern is because he turned in the writing?
No, I turned it in.
Where did you get it?
It was on my desk.
Okay.
Apparently,
I can't say anything other than that.
It's my understanding, Your Honor, that, yeah, the victim probably went to the public defender's office, filled out the statement, but that would not comply with what's required of the order. And I have reasons for, I can't even explain it to the court.
Well, this is what I'm going to do then. When probation talks to her or she drops off something at their office, then it'll automatically switch.
Yes.
So you don't have to come back to court, but it has to follow the rules that were given in court. That's what I'm saying. It hasn't happened yet. But if she does it this afternoon or tomorrow or whatever, if she magically finds out again and does that, then that's the way it'll go.
I guess I just spoke with her. She portrayed to him that it's not you got sentenced on Monday. He wants to be back home today, and she was just saying, look, we can't make all this magically happen in minutes. The victim hasn't come to our office. She hasn't spoken to our officer. So that's why I guess he came here.
Came here because because she had suggested it, and B, Your Honor, she had indicated that an order would have to be submitted to you. And when we were speaking earlier today, they said that as well. And so then I guess that's why Ms. Mathis had suggested to him, or that's what he
When probation
understood.
sends me an order, that means they've done everything that needs to be done, and I'll sign it.
And
what do you say?
And I also don't want to set the precedent that people can just come to court and say, hey, can you readdress this real quick? Because people aren't prepared for that. No one's reached out to her. One of the big things that, I'm still going to bring over from injunction court is making sure that I talk to victims if there's a concern, or at least know that the state attorney's office has talked to the victim that they want the contact and they haven't felt they've been pressured or threatened or coerced into it. I don't mind resolving it, but it has to be done the way that was discussed in detail on Monday.
Your Honor, I do have a phone number, it looks like, with the victim's phone number. We can reach out to the victim.
If you reach out and you get me an order, I'll sign it this afternoon.
Right, we'll reach out to the victim, ask her to come to our office, fill out the same notarized statement. Not tell her to, if she wishes to.
If she wishes to.
And then we will submit an order. Is that fair?
That's fair, and just, send it to my assistant via email and, show it as high priority, and I'll get it signed right away. I just want to make sure we're doing it the way we said we were going to do it, and not allow people to, I'm not saying that Mr. Willis is trying to cut corners here, but making sure it's done in the way that was talked about on Monday.
We will do that, Your Honor.
All right, thank you, Mr. Berry. Mr. Scott, are you ready?
Yes, Your Honor.
All right, come on up.
I'll call Gamble first. Thank
Okay,
you. Yeah, Gamble's not going to take long. McDonald is the other. Your Honor, Chris Scott here on behalf of Bravin Gamble, cases 23 CF 1540 and 13 CF 641. Your Honor, we're here today to see if Mr. Gamble wanted to enter a plea. He does not. Instead, we're going to request that his VOP is set for an evidentiary, if it hasn't already been.
I would ask Your Honor for a date after February 6th, because I already have some hearings that day.
hearings are set that afternoon?
This morning, I think Ms. Loney and I each got a VOP hearing set the afternoon of.
I just don't know which one. I'm seeing that there's 3 cases set at 2:30, which are Horn with you, Miss Leone, Marshall with Miss Basso, and Napoleon with Miss Turner. Do you have more than that?
No.
What's the allegation as far as this particular VOP with Mr. Gamble?
Allegation is the new law violation. He was in jail when he committed the crime, the new law violation.
So 23 CF 1540 is the new law violation?
Yes, Your Honor.
So that means it's
old.
a year and a half old?
Yes, because several times I tried to set the evidentiary hearing, and every time the defendant, represented by Mr. Gibbs, decided to continue it, and we played the game to place it on the pretrial docket, place it on for a VOP evidentiary. I subpoenaed the officers here more than once for him.
Scott, I know you don't seem to be involved with that from what I just
No, it wasn't Mr. Scott.
Anything you want to tell me about how things went, or give me your client's side of that? I don't want him to blurt out anything that could be detrimental.
Yeah, and I don't know, Your Honor.
Your Honor, may I speak?
If you'd like to, but you can consult with your counsel first.
Yes, sir, I'd like to speak.
Okay.
Yes, this is actually 18 months old, but I was originally arrested for case 23MM2409, and that's what violated my probation, which was a VOP on site. Case 23 CF 1540, I was charged with charges on the correctional officers on July 10th while being incarcerated in the jail, but I was never arrested nor went to first appearance for that case. However, I never received a VOP for these charges, but these charges was just added to my violation report after the fact my probation had already been totaled from case 23MM2409 on July 9th. Yes, sir. From case 23MM2409 on July 9th, 2023, which is a clear violation of Florida Rules of Criminal Procedures 948.06E1A, which states at a first
You didn't
appearance.
have a first appearance on July 12th of 2023?
No, sir. I was housed in MHU, medical housing unit. I never went to first appearance. I have papers that was printed out from a sergeant to me showing me that it was false documents filed. My signature was forged on it, and I don't know what judge name this is on here, but the judge name was on here. Can't really read what it was, but I never seen nobody for first appearance. I never got a bond on these charges or nothing like that.
Well, the record that I'm seeing shows that you're listed as a violent felony of special concern. So you're not entitled to a bond. Because you're on probation for home invasion, and now there's been probable cause finding that you violated your probation with a new charge, right?
Yes, sir.
So you're not entitled to a bond. Go through a little bit of the history of the case since I'm not familiar with it. I know Mr. Scott
Yes,
is
sir.
very new to it as well.
Yes, sir.
Looks like there was a Nelson hearing on October 31st, which led to Mr. Nelson being placed on the case. Fortunately, most of the minute sheet are just giving you court dates. So there was a Nelson hearing on both Mr. Gibbs and Ms. Flowers when she had it. So what are you asking for today, Mr. Scott or Mr. Gamble?
I mean, VOP court.
I think the concern is if it's based solely on the new law violations, it's basically be a mini trial for your new law case, right? So we probably need to have adequate time to do so. And I think what Ms. Leone from the state is saying is we've got a lot of other cases already set on that docket. We may run out of time.
Yes,
So
sir.
I'd hate to put it on a situation that we all run out of time and can't get it all done in one day. What do we have after February 6th?
Your Honor, I know you mentioned at the VFO that you're not entitled to a bond, but I've been studying the law a little bit, and according to Florida rules, criminal procedures 948.064 1AC states the county where the arrested person is booked should provide the following information to the court at the time of the first appearance.
It's not a criminal procedure rule. It's an appellate rule, right?
Yes, sir. Excuse me.
Just a quick tip for your studies. Each chapter of the rules, so chapter 1 is, so anything that's 1 point.
Yes,
those
sir.
are civil rules. 2 is judicial administration. 3 is criminal.
Yes, sir.
I believe 8 is juvenile, 9 is appellate, 12 is family law. If I'm not wrong, I could be. I've been in a lot of divisions over
Yes,
the
sir.
past few years.
I'm just learning.
I understand. I'm not trying to be critical of you, but what
No,
I'm
sir.
saying is you might be talking about something that doesn't really apply to your case. So if you look into the rules that start with 3, for example, discovery is 3.220, speedy
It
trial
starts with 1, sir.
3.191.
I'm sorry. It
You're,
starts
you're,
with 1.
you're in 9, so I believe that's the appellate rules.
Okay. But it states that the notice that the arrested person meets the requirements for restrictions on pretrial release pending the probation violation hearing or community control violation hearing in statute 903.03511B.
If you want to set a bond motion, you can do that.
Yes, sir. I would like to set that.
Okay, well then talk to Mr. Scott and he can file something to that effect, and then we'll have that for another motion hearing.
He and I
Yes,
talked
sir.
about it.
But both sides, just for the same reason that the state can't try to revoke somebody's bond without notice, they've got to file a motion and you deserve notice. We can't do the same thing to them where you say, I want a bond motion right now.
Yes, sir.
It can be done quickly, but at the same time, you know, you've been in for a year and a half and we need to resolve this case. So I'm going to ultimately put it on the February 6th date.
Yes, sir.
We'll see what pans out.
Yes, sir.
What is that February 6th date, Your Honor? Is that the
That's at
evidentiary?
2:30, that's an afternoon. It's kind of like today, where there'll be arraignments at 1:30, and then we'll have a couple of evidentiaries, smaller type things. Mr. Gamble's case might take a little longer than that. That's why I was hesitant to put it there, but I also want his case to be resolved and not put it to the end of March.
I got faith in Mr. Scott.
Say again?
I
You
said
got
I
faith
have
in
faith
Mr.
in-
Scott.
Yes,
I
sir.
hope so, because, you know, obviously the Nelson inquiries, as much as you're allowed to do that, I want to make sure we're getting to a timely resolution of the case. I've only been in this division for about a week and a half.
Yes, sir.
Mr. Scott seems to know exactly what he's talking about every time I've asked him a question. So let's see if we can't get it resolved on February 6th when we get back for your evidentiary hearing at that point. And then the new law violation, the 23 case, will also follow along with that date, February 6th, 2:30.
Yes, sir.
Okay, we'll see you back on that date, Mr. Gamble.
Sir, thank you.
Your Honor, next I'll call Thomas McDonald. Case numbers 24 CF 1992 and 24 CF 1961. And Your Honor, we're here on the issue of Speedy, and I suppose the state's motion to strike and for continuance.
All right. Did you want to provide me with anything else, Mr. Scott?
Your Honor,
It wasn't really, I mean, it's not a written demand for Speedy, right? It was just, At the
Not at this point.
pretrial conference on December 30th, y'all talked about setting the 1992,
Yes, sir.
24 CF 1992 case. Then we came back on Monday, the 6th, that docket day, and the state has some concerns about, I guess, witness issues, someone
Correct,
in
yeah.
jail in Santa Rosa.
Yes.
At which time y'all talked about him wanting to have a speedy trial. I looked at the dates as well. I think you said the same thing that date, Mr. Scott, that February 10th is his date for speedy trial purposes.
The arrest dates were a little bit different on these two felony cases, but it's in that ballpark. Your
Sure.
Honor.
And so, information's been filed during the course of the 175-day period, which means, you know, other than doing a written demand of Speedy, you know, nothing can really be done until the expiration, right?
Correct, Your Honor.
Also, there was a continuance back in October. One of my concerns, and I'll certainly say this, is that Mr. McDonald wasn't standing at the podium when that happened, but it was continued for purposes of an evaluation. I've read not only the section 3191 regarding delays due to mental health or competency evaluations, but also I found what's the Parks case, Parks versus State 278 Southern 2nd 332, and I can give you a copy of that if y'all need it. Which basically, it's a really, frankly, it's a pretty old case, but it came up when I was looking at the annotated 3191 about delays due to those types of evaluations. In that particular case, it delayed the case 27 days, and then he went to trial on day 184, which was 4 days past the old rule of 180, not 175 like it is now. So, in addition to the request for the continuance, but also the competency evaluation, there's certainly an argument to be made that he's waived his right to speedy trial, which can be restarted with a written demand. But Mr. Scott, I'll let you address that, and then obviously Ms. Leone, if you have.
Your Honor, with regards to the competency evaluation that has been completed, the report has been filed with the court. Proposed order was submitted to the court. I haven't seen that it's been.
One question on that.
Yes, sir.
The one thing we didn't discuss on the 6th, because I hadn't seen the report, I think the report had been filed, but I hadn't read it yet. We didn't talk about as far as a competency hearing. Are y'all willing to agree that the court can make its competency decision based on the sole evaluation of Dr. McDonald? Yeah. I looked at it yesterday, and I was, before I signed it, I realized we hadn't made that decision, because you can certainly say, I want another evaluation, or we're not ready for a competency hearing. We didn't really address that on Monday, so I wanted to address that before I signed it, even though it's only going to be a day difference.
Your Honor, I'm comfortable with the report that has been provided to the court. I know we're not here on the competency determination.
But if y'all agree that I can make the determination on the one report, then I can sign the order, and then we can kind of get the case moving. But it has, as the Parks case says, and 3.191 talks about delays due to those types of evaluations.
Well, Your Honor, I believe that those are in place to protect the defendant from proceeding to trial while the determination has not been made. And I know you haven't signed the order. However, Mr. McDonald has been determined competent per the report. We just need the court.
Yeah, I would disagree with that. A doctor has opined that he's competent. Until I make that decision, he hasn't been determined to be competent. I'm not trying to say I'm the one that gets to make that decision, but that's how it works. So.
Absolutely, Your Honor.
But I'll also point out, I believe in the Parks case, again, y'all haven't had the opportunity to read it, but it talks about the date of the filing of the report was the date the court was concerned about. So once that report came back that the person was competent, that's the date that the court ultimately used to determine how much of a delay was because of that competency evaluation, because it ended up being only about 27 days in that case. So when I read that, I didn't see a huge issue with, did I sign it yesterday or the day before or today? We're only talking about a couple days difference, but also there was some time from October till whenever the report was filed.
8.
that would be attributed to that particular issue.
Yes, sir.
But as far as, I mean, I'm not sure the speedy trial issue is even ripe at this point because we haven't passed the 175-day point, which, as Mr. Scott, I'm sure you know, once that happens, there are other options, but I can't really address the speedy trial issue at this point other than probably proactively thinking about how I'm going to fix any future issues, which I've got an idea on that anyway, due to the fact that if we do have a speedy trial issue, if I ultimately determine it wasn't waived or no delay has been attributed to the defendant, that I've got a civil trial week sitting in February that doesn't have anything on it. I'm not saying that that's the ultimate result, but if I ultimately determine after argument that we're in a situation where speedy becomes an issue after February 10th, I've got ways to fix that. So, state's still seeking a continuance.
Yes, and again, Your Honor, for the record, it has to be charged to the defendant. I also need to make the court aware of an additional argument that I have about the defendant not requesting speedy trial in good faith.
Is the deposition issue?
Not only that.
Okay, go ahead.
No, something in addition to that. I just realized that the day after docket day when we were here, his office on the 7th, and I have the emailed me requesting video evidence. Now, the request for additional evidence is exactly the opposite as claiming that you, in good faith, you're ready for trial, you prepared your case, discussed the matter, and you're ready to proceed. He scheduled the issue of the depositions, exactly. He scheduled the deposition. The only reason why they didn't take place is because the defense counsel made a mistake in scheduling it at our old office in Shalimar, which has been closed for over 2 years, almost 3 years. So it wasn't on the state's fault. It wasn't because the witnesses didn't show up. So I went under the impression that he was investigating the case. He needed to investigate it. And again, if it was ready and in good faith, he wouldn't have asked me for video evidence that he claims he doesn't have. But we do have record that has been shared in the past.
Well, again, I think we're still talking about a speedy trial upon demand, which hasn't been done. So I think you're right to make the arguments you're making if a written demand for speedy trial had been made, but it hasn't. You know, just simply saying, you know, he wants a speedy trial, I don't think invokes 3191B.
That was
So,
my
but it's certainly an argument that will be made if that were to happen.
I'm making this argument to charge the continuance to the defense, Your Honor.
Which continuance? This one?
This continuance, yeah.
I guess my point is, on December 30th, he wanted a trial. You said there was issues with the other case, the 24 CF 1961 as far as witnesses, but we said, okay, then it's going to be a trial on 1992. And
But only because, Your Honor, because when I made the argument that it should not go to trial this cycle because of invalid speedy trial demand, I guess I wasn't heard on that.
Well, I think the speedy trial issues isn't ripe yet because we haven't passed that date. And information's been filed. We haven't hit day 175 yet. My only real concern about it is, again, being somewhat proactive to figure out if it's going to become an issue and how can I, as the court, fix that issue if it were to come up. But I don't think any of these arguments really have to be made yet because speedy trial hasn't expired yet.
Not only this, and the other thing, Your Honor, I want to specify, even if he had not sought a continuance and therefore he had not waived speedy trial, he still has to file a written expiration of speedy trial time because that has to allow the state to have the 10 days and all of that. So it's not
Well, if something were to be filed after the actual expiration, then
That's when it's timely filed.
But it still has to be in writing. It cannot just be
but
asserted.
it can't be filed until after the February 10th
correct.
day.
Yeah.
So, and that's what I'm saying is I think a lot of this just isn't ripe yet.
And Your Honor, on December 30th, when we requested that it be set for trial, we set the 1992 case for trial, there seemed to be no objection to 1992 being set, so that solved everything at that point. But it was the subsequent hearing where the state then objected to it, and then now is asking.
When they realized they had witness issues.
And then
which
now
is why we have
ask for
time
the-
between those 2
The
dates.
continuance, that's why I'm asking that if the continuance is granted, that it's not charged to the defendant.
All right. Again, I don't think it's ripe for the speedy trial argument. So what I'm going to do is, based on the state's request for a continuance, I'm going to grant it. Okay? I'm going to put it on the February 24th pretrial date. If something after that, after the magical date everyone's talked about happens, then we'll address these things. I just don't think it's ripe to do so yet because we haven't passed that date. And frankly, a lot of what we're talking about is kind of assumes there had been a written demand for speedy, which there hasn't been at this point. And even then we would go through all the analysis of what's been done, who's it attributable to. I just don't think we're there yet. I mean, I appreciate that, Mr. Scott, you and or your client giving me the heads up that this could be an issue once we hit that day 175, which is a month away. But I think I've got it handled if that does happen, that I can potentially resolve it with a trial after the 5-day recapture and the 10 days for trial. We can get a trial within that date if we need be. If ultimately after the notice of expiration is filed, I determine there hasn't been a continuance attributable to the defense, even if just for the short period of the evaluation time. But I don't think I should be making that decision yet because we have to get everything in the proper sequence.
And 1 second, Your Honor, one other thing to keep in mind is that when there is a competency evaluation, and I do provide case law to the court and defense counsel, the speedy trial period is told. So it needs to be recalculated based on that. And
I understand that, but again, we're not there yet. If he files a notice of expiration after February 10th,
then we'll argue.
Then we'll argue, and you can say, well, it shouldn't, the 175 days should have told because of the X amount of days between the order for the evaluation and the receipt of the evaluation. And then I'll address it at that point. I don't like the idea of making decisions saying, when something happens, this is what my decision will be.
And Your Honor, I believe I have, and I will share, case law that says it's not necessarily told, it can be told with that period of evaluation. But I understand, and I.
Oh, I've read the order appointing the evaluator because I was concerned if it had any language that specifically said that or not. But again, despite the fact that we've somewhat argued it already, I don't think I can make a ruling based on things that haven't happened yet. You know, it's kind of preemptive at this point.
Thank you, Judge.
May I inquire, since we're on the record, just not to have any confusion, if a defense counsel intends of continuing with discovery or not, or as he said, he was ready for trial, and I should just assume that we're not doing depositions and anything else, correct?
Well, again, I think there's a difference between the I want a speedy trial comment in court versus an actual filing of something. Once you file something that says, I want a speedy trial, you're basically saying, I'm ready for trial. And if you come after that and ask for new things, unless you didn't find out about those things until after the demand for speedy trial, what's the word it used? I think it's a word I'm trying to remember from the case law, but it basically, you know, what did
Bonafide
obligate to you,
intent?
or say again?
Bonafide intent.
Yeah, you can't say I want a speedy trial and then engage in more discovery that could have been done beforehand. Because we don't want to be in a situation where you say, I want my speedy trial, but like, all right, well, we haven't turned over certain things yet because we don't have them, and now there's some concerns about whether or not, I'm not going to say they have to turn them over, obviously. Exculpatory evidence, they always got to turn it over, but it puts us into a real quagmire of difficulties. So I'm trying to do these things in sequence so we don't get the cart before the horse and cause more problems than we're fixing. But Mr. McDonald, I'm reading everything. I'm trying to stay on top of it. I know you want your trial as soon as possible, but we also have to work within the system and the rules that are written.
So, can I say something?
Yes, sir. Mr.
So,
McDonald.
are we getting?
Do you want to discuss that, whatever you're going to say with your counsel first?
Thank you.
I haven't made that determination. I'm not saying it's their fault. I'm not saying it's your fault. I'm not saying it's nobody's fault. I'm just saying I'm not making that determination yet because it's not right to do so.
Yes, sir. Thank you, sir.
All right. Thank you, Mr. McDonald. Anything else?
The order on competency, Your Honor, we cannot do
I
anything.
will sign it now that y'all have agreed that I can make that decision based solely on that.
Okay,
I
okay.
mean, I'll sign it while we're sitting here. It's in my box. I can just click because I've already read it. I just didn't want to do that until I heard from the two of you that you stipulated to it.
Yes, sir.
And that's my fault for not bringing that up on Monday. I should have asked that question. We just had a million cases going. I didn't think to make that extra step. So I'll take my blame on that part. All right, February 24th. We'll see you back on that date. Obviously, if something happens between now and then, we'll address it.
Yes,
All right,
Your Honor, thank you
you.
very much.
Did you have anything else, Mr. Scott?
No, Your Honor, that's all I have. Thank you.
All right.
Your Honor, we're ready now on Mark Wayne Williams, 24 CF 2767.
All right, Mark Williams. Y'all hear that?
Yeah.
Buzzing noise.
Can't hear it.
There. That's back.
It's you.
If I may approach, Your Honor.
Fall out.
Judge, may I be excused? That's all I have today.
Thank you, Ms. Rivers.
Judge.
Excuse me, Your Honor.
It's okay. I just wanted to make sure I wasn't hearing something that no one else was. Okay. Let me take a look at this real quick, Ms. Rivers. All right, this is Mark Wayne Williams, 24 CF 2767. Mr. Williams, can you raise your right hand to be sworn, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Do.
All right, can you state your full name and your date of birth?
Mark Wayne Williams, 10/31/1964.
Okay, Mr. Williams, I've been given a plea and sentencing agreement in the case I just mentioned that would have you plead for probation for the aggravated battery as well as the resisting without violence. Is that what you want to do today?
Yes.
Did you go over this form with your attorney, Ms. Rivers?
Yes.
Did she explain it to you?
Yes.
Did you understand it all?
Yes.
And did she answered all your questions?
Yes, Your Honor.
Okay. And are you satisfied with her advice and representation?
Yes, Your Honor.
Are you under the influence of any alcohol, drugs, or controlled substances that could affect your ability to make this decision today?
No, Your Honor.
Any mental health issues or concerns that could affect your ability to make this decision today?
No, Your Honor.
Anyone force, pressure, or threaten you in any way to enter into this agreement?
No, Your Honor.
And anyone promise you anything in return for your plea to this agreement?
No, Your Honor.
Did you understand that by entering a plea, you're giving up your right to a trial and all your trial rights that are enumerated on the first page of this document?
Yes, Your Honor.
And you understand you're waiving any potential defenses that you may have?
Yes, Your Honor.
All right, and what is your plea?
Guilty. No contest.
No contest. Is this the state's agreement, Ms. Lee?
Yes, Your Honor, it is.
All right, and I see the state signed it as well. All right, I'm going to accept your no contest plea as to the aggravated battery with great bodily harm, count 1. You understand that's a second-degree felony punishable up to 15 years in prison.
Yes,
So
Your
if
Honor.
you were to violate your probation, that's the potential sentence you could get for that charge.
Yes, Your Honor.
All right, and resisting an officer without violence is a first-degree misdemeanor punishable up to a year in county jail. Do you understand that?
Yes, Your Honor.
Do you understand if you violate your probation, you could get that?
Yes, Your Honor.
Okay. All right. It's a withhold of adjudication as to both? There's nothing that says adjudication is necessary on an aggravated battery, right? Just want to make sure.
If you would like, Your Honor, I can verify,
If you
but I
can take a
don't.
look at that while I'm going through the rest of it, and the reason I say that is because I think I saw something where a plea form or something like that recently, and I want to make sure, it didn't seem right when I saw it, so I want to make sure that we don't have an issue for Mr. Williams. All right, so withhold adjudication, 3 years of probation on count 1, 1 year concurrent probation on count 2, successfully complete batterer's intervention, substance abuse evaluation and compliance and completion of that, including any counseling that's recommended as part of that substance abuse evaluation. No alcohol, no weapons, no threats of violence, that's towards anyone. Waive cost of supervision, $867 in court costs, $100 cost of prosecution, $100 PD fee, $50 application fee, and then no violent contact with the victim in the case, Gail Williams.
Your Honor.
Okay, you understand all that?
Yes, Your Honor.
Got the score sheet that shows 34.65 months minimum sentence. So is this an agreed upon plea bargain for downward departure?
Yes, Your Honor.
All right, do you understand that, Mr. Williams? Your minimum sentence, if they didn't agree to it, would have been at least 34 months in prison.
Yes, Your Honor.
Okay. I am doing that. Again, I accepted the plea. I've given you your sentence. Step over and talk to probation, then you'll be fingerprinted. Well,
None haven't been
do I need a fingerprint if it's a withhold? Well, it's a battery. I still think I need it. It'll be, excuse me, fingerprinted.
Okay.
You have 30 days to appeal.
Where'd I go now?
Thought I said that, but if I didn't, Mr. Berry?
I'm going to be putting the cart before the horse here. Also, heard Mr. Rivers talking to our client, a reference that he may live out of state. Has to go through the interstate compact process, and there's a $100 cost of transfer.
I told him that.
Compact fee.
Yes, I told
It's
him
not
that too. I
immediate.
told him that to be approved, the other state.
Mr. Bear, do y'all still do potential travel permits for that while you're doing? I'm just trying to remember what it was like 3.5 years ago, the last time I probably pled someone out to probation. All right, go ahead.
Yes, Your Honor, that stopped about 3 years ago. And they also imposed a $100 fee. Ask the other state. But we're not allowed to give travel permits, even if they're a resident there, until we get an answer back from the other state. And if they're found in the other state while we're asking, they'll automatically deny it.
Even if they're a resident.
Is
Even if
there
they're a
a,
resident. So we tell them,
So,
between 1 and 7 days, they need to plan on staying here. Ask for immediate.
explain this to me. If someone comes here on vacation and leaves on probation, as the old adage goes, do they have to go through the same compact, even if, okay, because I think that was one of the issues. If they were living, they were just here and they lived there before it happened. But again, I'm basing a lot of this on rules from 3 and 4 years ago when I stopped practicing.
That is the situation.
If they're on for a misdemeanor, no, they don't have to do compact. But if they're on for a felony, yes. And like I said, we ask for immediate reporting instructions, which they have, I think, 48 to 72 business days,
Hours.
Yes, sorry, hours, yes. To respond back, and then we can let them go. So we just tell them 1 to 7 days. Plan on getting a hotel room and staying until we get that.
Is there a way to preemptively do that? You know, I'm going to plea next week. Can I go ahead and,
No. We tried that.
I'm sure you have. I'm just,
Yeah, and it's not Florida's rule, it's the interstate compact.
well, I understand that. I'm just trying to remember how it works, or at least be reminded that it's changed, because
We tried everything we could, and
Yes.
guess what? We hadn't found anything that works.
it used to work a little bit differently, but it's been a while.
Especially when we're the ones sitting there telling them, you can't go, and they're looking at us
Yeah, you're the bad guy now.
for you to tell me I can't go home. Well, I'm just telling you what the law is, or the rule is.
What's that? Yeah, beats jail. Yeah. Well, I'll take a Red Roof Inn over, the Gray Bar Motel or whatever they call it, so. Who's that?
Property out.
Oh,
They
okay.
want to move back.
Is that Mr. Weeks?
Weeks.
Anthony Weeks. That's Miss Bosso's case, and before she left, she told me that that was continued. There was actually an order signed yesterday, maybe didn't go through. You know, like,
Let's see.
it should be continued.
It's on my docket, but it's not on the clerk's docket, or it's not on my, smart bench.
I'm fine if they want to bring him out and we tell them, it's fine.
It's